Welcome back to Legal Briefs. A U.S. Court of Appeals has ruled that a professor who rejected using transgender pronouns can sue the university because his lectures are protected by the First Amendment. That's what we're going to be talking about today. Hi, my name is Wes Austin. I'm a lawyer trying to keep you updated on the latest legal news. So here's what happened. At Shawnee State University, this university in Ohio, they came out with a new rule saying that professors had to use the preferred gender pronouns that students wanted them to use. This philosophy professor, Nicholas Meriwether, he refused to follow this new rule, saying that it didn't follow biological reality, and also it contradicted his Christian beliefs. So Professor Meriwether, in the first class he had with a student named Doe, Doe had asked a question, and in response to that, Professor Meriwether had said, "Yes, sir." And I guess that really pissed Doe off. So after class, Doe approached the professor and demanded that the professor use the female pronouns. And we're going to read the language right from the opinion. This is from the Court of Appeals for the Sixth Circuit in discussing how Doe was acting around the professor right after class, after the first class, after he said, "Yes, sir." Doe became hostile, circling around Meriwether at first, and then approaching him in a threatening manner. "I guess this means I can call you a C word." Doe promised that Meriwether would be fired if he did not give in to Doe's demands. Now remember, that's the first day of class. So sometimes the first day of class, you could just give your teacher an apple. I guess this is another possible way to approach that. So anyway, after that happened, the student Doe complained to the university saying that the professor wasn't following this new policy, and because of that, it was creating a hostile environment. And I believe the terms that the professor had used where he said, "Yes, sir," that one time, and then I think there was another time where he said "Mr." instead of "Mrs." But from my understanding from the case, it seems like the professor, for the most part, just referred to Doe by Doe's last name. So he wasn't continuing to just always try to use the other pronoun that Doe didn't want, but he just would refer to Doe by Doe's last name. But there were those few occurrences where he had said "Yes, sir" and "Mr." instead of "Mrs., and that was the basis of the complaint. Now, when this policy came out, Professor Meriwether was concerned, and so he approached the chair of his department, Jennifer Pauley, to talk to her about it. And she was not super nice about it. So she knew that he was Christian and that he taught some religious courses. And this is what the opinion said about how Jennifer Pauley reacted to Professor Meriwether approaching her. She said that Christians are primarily motivated out of fear and should be banned from teaching courses regarding that religion. In her view, even the presence of religion in higher education is counterproductive. So, Christians are not Jennifer Pauley's favorite religion, and not her favorite teachers, apparently. But Shawnee State University, they took action. They sent her a strong message. I got this from a web page on Shawnee State University's website. It looks like they promoted her to interim dean of the College of Arts and Sciences. All right. I hope you got the message. Yeah. You won't try that again or we'll promote you again. Happy Easter, Jennifer. So in response to the complaint that had been filed by the student Doe, the university sent a warning letter to Nicholas Meriwether, warning him that you needed to start following our policy, and that if you don't, you could be suspended and or fired. Well, in response to that, Nicholas Meriwether, he filed a lawsuit claiming that the university was violating his freedom of speech, his free exercise of religion, and there was also a few other claims. He was concerned that, hey, if I ever want another job again with this written warning in my history, I won't be able to get another job. And up until this point, Professor Meriwether had a spotless record at the university. So it's nice to know how fast they can turn on him when they find out he has a religion that he believes in, so they can just turn on a dime if they want to get you. So this went up to the Sixth Circuit Court of Appeals, and the Sixth Circuit Court of Appeals, in a unanimous ruling, said that the school was violating Professor Meriwether's freedom of speech and free exercise of religion. Look, we can have universities overcharging for an education that turns out to be worthless, and we can have them making billions of dollars off of sports where they don't pay their athletes anything. But let's draw a line and say when a university starts attacking and harming the First Amendment and people's freedom of speech and free exercise of religion, we do have a problem with that. Let's have that be a line in the sand that they can't cross. I mean, those other two things are fine. But First Amendment, all right, that's it. Now here's some of the language from the opinion from the Sixth Circuit that I thought was some great language. If professors lacked free speech protections when teaching, a university would wield alarming power to compel ideological conformity. A university president could require a pacifist to declare that war is just, a civil rights icon to condemn the freedom riders, a believer to deny the existence of God. That cannot be. So this lawsuit has been sent back down to the district court. The district court judge had dismissed it in February 2020, which is where they appealed it up to the Sixth Circuit. So it's going back down, and Professor Nicholas Meriwether can pursue a lawsuit seeking damages. All right, thank you for watching. We'll see you next time.